Guys, I want to talk to you for a couple minutes today about something really interesting and not really discussed. At least not something that you would hear anymore these days, just walking down the street or in typical conversations. And that is the Third Amendment. Now, the Third Amendment in the Bill of Rights says no soldier shall, in time of peace, be quartered in any house without consent of the owner, nor in time of war, but in a manner to be prescribed by law. This, along with the other amendments in the Bill of Rights, can be found at constitution.findlaw.com, and brief summaries and explanations of what they mean can be found at www.archives.gov. Now, the Third Amendment, what it does is it prevents people, just average citizens, homeowners, from having soldiers forced upon them to live in their house. They don't have to home or house them in times of war or in peace. And this was written as an amendment because prior to the Revolutionary War, the British, by law, were actually allowed to force soldiers upon people and have them stay in their homes of regular citizens. And this is not to say that it could never happen, like the government could never have soldiers stay in a house, but it has to be by the homeowner's permission and consent for that to happen. It can't just be forced upon them. They can say no. Now, the extent of this amendment doesn't stop at just housing and quartering soldiers, but it also implies the right of an individual's property, like they have a right to their own property, as well as it's really cool because it's the only part of the Constitution that really addresses the relationship between the average citizen and the military and what their dynamic is kind of with each other. Now, in today's society, at least in the United States, there's not many issues that really come up at all with the Third Amendment because that's not something our government does. In fact, there has never been a Supreme Court case that has been decided on the basis of the Third Amendment. Now, there was another case. I'll bring that up in a second. But according to legaldictionary.net, they say, referring to the Third Amendment, it is also so rarely contested that the American Bar Association has referred to it, the Third Amendment, as the runt piglet of the Constitution. Now, back to the other case that actually has happened in relation to this amendment. It's referred to, or it's called the Engblom, I might be pronouncing that wrong, versus Carey case, and that occurred in 1982. So even that was 30 plus years ago. Now, Marianne Engblom and Charles Palmer were two New York State corrections officers, and they filed a lawsuit against their Governor Hugh Carey. These two people who filed the lawsuit, along with other officers, previously had been on strike, and their place of living was provided by their employer, and so they were living on the property of their employers. They were living on property grounds, but they all had their own rooms and stuff, and when they went on strike, they were kicked out of their rooms, so they weren't housed there anymore while they were on strike, and those rooms were filled with National Guardsmen, who then performed some of the duties of the corrections officers who went on strike because they weren't there doing their job, they were striking. So National Guardsmen were put in their place as a substitute to get the jobs done, and they were provided the living space that the corrections officers had had. Now, the corrections officers, specifically Engblom and Palmer, were very upset, and they called it against the Third Amendment. They said that went against the Third Amendment. And the case went through a couple different things and different arguments were brought up, but it was ultimately decided in favor of the governor on the side of the state, stating that the state had not done anything they knew would be illegal. This is also referred to as qualified immunity. And considering like the case and the issue of something going against the Third Amendment had never been brought up in court before. There was no prior decisions that had ever been defined in court for there to be something to base it off of. So, since it did go to trial, 3 major boundaries for this issue kind of were established. And first, it was that the National Guard definitely qualified as soldiers. Also, the Third Amendment applied to state authorities, not just federal government. And lastly, the Third Amendment, it covers people in residencies that have a right to privacy there and the right to exclude others like from entry onto the property, in addition to simply just homeowners not being able to be forced to house and quarter soldiers. Now, the case itself can be viewed in major detail at law2.umkc.edu. Very interesting, and I hope you guys enjoyed learning about it. You can definitely look it up and find out more.